Cześć Robert.
Hello Bartek.
How are you?
Good.
So I have you here, but I have you here as Andrea Woods. So you have used the link of Andrea Woods. You need to disconnect and I will send you a link. Hey, that's better.
Okay.
Tak jest dobrze.
All right. I am somehow visible under my email address only.
Yeah, I couldn't, wiesz, nie mogłem po prostu podać twojego nazwiska tym razem, nie wiem czemu, ale tak mi się podało. W każdym razie ciebie nie będzie widać, więc ciebie zrobimy hide, o, w ten sposób i wtedy nie będzie ciebie widać. Natomiast ty musisz sobie ustawić tam, zdaje się, w interpretation polski.
Ale nie mam właśnie teraz tych rzeczy, które miałem wcześniej.
Pewnie dopiero jak zaczniemy, to będzie możliwe.
Bo ja rejestrowałem się teraz jako uczestnik i nie wiem, czy to jest to samo.
Nie, on cię rozpoznał jako tłumacza, tylko nie wiem, czy ciebie, ale by cię nie wpuścił, gdybyś nie był dopuszczony bo to jest practice session. A skorzystałeś z tego linka, co ci wysłałem?
Tak.
Okej, czyli...
Tak, teraz tego ostatniego. Click the link below to join.
Ja ci przed sekundą wysłałem odpowiedzi na twojego maila o Quizlecie.
No tak, w odpowiedzi na Quizleta, dokładnie. To ten link kliknąłem.
Dobra.
Ale jeszcze jakiś inny przyszedł link. Join from a PC.
To samo powinno być. Ja ci po prostu wysłałem to jeszcze raz.
Dobra. Okej.
Czytałeś ten materiał od Andrei, a czytałeś bo ten Andrei czytałeś, natomiast ten od...
No wiesz, tutaj to, co dostałem, tam ten kodeks, to trochę było tego dużo, ale...
Tam kilka pierwszych artykułów,
co
nawet
przeczytałem.
279 bodajże. One 249, przepraszam bardzo, nie?
Ja jestem, cześć.
O, hej.
Rozumiem, że widać, słychać, nikt nie wisi.
Tak, jesteśmy połączeni i w ogóle wyglądasz świetnie, także dobre połączenie jest. Dobrze cię słychać.
Dziękuję, jesteś troszkę świnią, bo nie dlatego wyglądam świetnie, że jest dobre połączenie, no ale dobra, okej. Noted.
Słuchaj, cieszę się,
Dzień dobry, witam.
że to wiesz. W tle jest Robert, który będzie tłumaczył dzisiejsze spotkanie na język polski.
Ja wziąłem to tłumaczenie z Lexa, bo my mamy na przykład w katedrze, myśmy sami tłumaczyli. Doktor Witek Zątek tłumaczył kodeks karny, ale KPK-uśmy nie tłumaczyli. I jakby no, problem trochę polega na tym, że nie wiem, kto tłumaczył to do Lexa. To jest aktualna dość wersja KPK, natomiast rzeczywiście tam niektóre terminy w perspektywie tego, o czym których używają Amerykanie, to nie mają nic wspólnego z polskim prawem karnym, jakby postępowaniem karnym, bo nie wiem, preventive measures a precautionary measures i to jest u nas, jakby jak my to tłumaczymy, można to tłumaczyć łącznie jako środki zapobiegawcze, a preventive raczej jako zabezpieczające i to tak pierdolca można dostać. No.
Bardziej szczegółowo jest w angielskim.
No, ale to jakby myślę, że tym się nie będziemy jakoś szczególnie tutaj przejmować. No.
Ja prawnikiem nie jestem, to od razu uprzedzam.
Nie,
chociaż na pewno jakieś doświadczenie
3
mam.
minuty dosłownie właśnie a propos języka, żeby jakby powiedzieć, dlaczego ja nie będę mówił tak, jak jest w KPK, ja nawet nie wiem, jak oni to przetłumaczyli. Ja będę mówił pre-trial detention, bo to ta pani ze Stanów, ona będzie to rozumieć, nie? A dla nas jakieś precautionary, nigdy nie wiem, jak to się mówi, precautionary arrest, warrant arrest i tak dalej, to Amerykanie, mam wrażenie, że tego nie rozumieją, przynajmniej po moich wizytach w Stanach, jakbyśmy o tym gadali, to problem był taki, że no ale o czym ty mówisz do mnie, nie? No po prostu.
Tak.
Oni mają po prostu pre-trial detention i chyba nie mają takiego określenia ogólnego na wszystkie środki zabezpieczające.
Nie ma zapobiegawcze, bo zabezpieczające to szpital psychiatryczny, nie? No, to ja to właśnie dlatego tylko w dwóch zdaniach wytłumaczę, dlaczego ja będę używał tak, a nie inaczej, na zasadzie takiej, żeby nikogo tam nie mylić.
Zapobiegawcze. Robert.
Przetłumaczyli, czekaj, w tym leksie jako Wojciech, aż coś z ciekawości zobaczę, bo sobie to otworzyłem.
To jest precautionary measures, tak? To są te?
Oni to przetłumaczyli jako precautionary measures. Cały rozdział tam od 249, czyli środki zapobiegawcze. Natomiast moja żona, która się zajmuje środkami zabezpieczającymi, też jeździ, zna angielski w tym sensie, no, na ile możemy znać, nie? To cały świat używa z kolei na środki zabezpieczające, czyli tam wsadzanie do szpitali psychiatrycznych i tak dalej, preventive measures, nie? A jednocześnie spotkałem się z używaniem gdzieś na konferencjach zagranicznych zamiennie preventive i precautionary measures, więc szczerze mówiąc myślę, że to dla nas nie ma większego znaczenia, tylko żeby wytłumaczyć dlaczego, w jakim kontekście będziemy tego używać i tyle, nie?
W każdym razie, Robert, jak będziesz tłumaczył na polski, to chodzi o środki zapobiegawcze.
Środki zapobiegawcze, dobrze.
Tak jest, środki zapobiegawcze, dokładnie.
Tak samo jak z tym poręczeniem majątkowym, nie? Po prostu dobrze jest używać tego terminu, żeby się utrwalały te poprawne terminy, nie?
Tak, mimo że tak jak rozmawiali z Bartoszem, to, że ja będę mówił bail, to trochę jakby Amerykanie będą rozumieli co innego pod tym jakby w tym znaczeniu niż my, no.
Tak.
Rozumiem, że tak. Ja nie mogę bez słuchawek, bo to nie problem, bo jestem w gabinecie.
Słuchajcie.
Ale rozumiem, że my tych tłumaczeń nie będziemy na szczęście słyszeć w tym sensie, że to pan Robert...
Tak, teraz zobacz...
tłumaczył jakby tym, którzy wybrali tą opcję.
Wojtku,
dokładnie.
Hello, Andrea. Nice to see you.
There.
Hi. Andrea, we've just started talking how to solve the technical issue with translation, with interpretation. So in the background, there is Robert, who is our interpreter. So you can say hi to Robert. he can hear you probably. At the bottom and in the menu of Zoom, you can find interpretation function. And then there you can switch to English. So the system will know that you're speaking in English. And whenever someone wants to hear interpretation in Polish, he won't hear you, he will hear or she will hear Robert.
Okay.
So this is Wojtek. This is
Hi, great pleasure to meet you. I have in this interpretation box off.
You should pick English.
Okay.
Let's pick English for us.
My first pick was off. Okay, so now I am picking English, and English it is. All right.
So now someone that wants to listen us in English will have our original audio, and someone that wants to listen us in Polish will receive Robert's voice.
Okay.
Okay. So how are you today, Andrea? How is your morning?
It's going fine. Yeah. How is your evening? It's funny with the time difference.
It's about
5 p.m. 5 p.m.
5 p.m.
in Poland,
but it's getting dark already. Yeah.
It just started to get cold here. It's been warm and sunny, and then this week it became fall for the first time.
So when you get frost in New York, when is the time for having some?
A few more weeks, maybe November, but it's been unusually warm for October, so I can't complain.
You don't like snow and stuff.
It's not my favorite.
Okay.
So you should learn how to ski. Skiing is the best activity during winter.
Yeah, I should. I run, but I'm not very coordinated.
Running in the snow, it's probably much more difficult than skiing.
Yeah.
You can run on skis, actually. It's quite popular in Poland. I don't know the name for it. It's ski running, maybe. It's popular. How do you know it? The name for it?
No. I don't know the English word for this sport.
It's cross-country skiing.
Oh yeah.
We have the professionalists with us, so it's cross-country skiing. Okay.
I still remember.
Yes, very good.
Let me just fetch notes, and I'll be back with you in a second.
Okay.
Actually, I like mountain biking, so cross-country for me is very like close, you know.
Mm-hmm.
But mountain biking is also available, as I can say it right, in winters.
Yeah, you can ride a fat bike.
Yes.
With those really wide tires.
Yes, true. Although probably, as you said before, it's unusually warm. Probably everywhere in the world we are facing the same changes of climate. So in Poland also is today over 22 degrees centigrade. So it's also unusually warm as for October. I know 10 years ago, it was snowing this time. So we are, of course, waiting for the winter. It's fall, autumn right now, but also it's unusually warm, unfortunately.
Yeah, it is scary.
Yes, it's very scary. And our government, I know if you hear it, is facing some charges from the EU still as our coal, as we are using a lot of coal to produce electricity, unfortunately still. And we have facing also, especially in Krakow, but maybe not right now, a problem of polluting of air pollution also, unfortunately.
I'm in no position to judge. The US is terrible on climate. It's very sad. And
well, it's always good to talk with Poles, because we always complain on Poland and how bad it is, so you can feel better.
Yes.
Yeah, I don't know if we're any better. I don't think we are.
Yeah, the topic that we're having today is as well a topic where we can only complain.
We will argue for this next hour who has the worst states, who's the worst problem, states or Poland in this manner.
Wow.
I have the question, how many cases, 98%, 95%, are ended with plea bargaining?
It's about 95 to 97.
95. After some amendments in our criminal procedure, it was in 2003. we increase this percentage, but as far as I know, right now it's about 50%. 50%. Still, for us, it's a lot, but this number is decreasing because of some problems with our government, with our politicians, because the head of public prosecutors in Poland is a politician. And there are some decisions about penalties that
Wojtek, I need to stop you there. We will
because it's 5 p.m. Oh, sorry. Okay.
It's 5 p.m. in Poland, so we should start. I will switch us to broadcasting. So let's start it. So our participants are joining us now. As we have just started our broadcast, I will quickly explain the technical issues concerning our meeting. I will also greet our participants in a second, as I see that they join our meeting now. And I will explain how to pick Polish translation. So I hope everybody will get it. I will switch to Polish for a second just to let everybody know who's there haven't picked the language, how to choose the language version. So I'm just observing as the number of participants is rising. We have already 29 people join our webinar. We are expecting some more. As I've checked for the last time, it was about 80 people registered, so we can expect about 40-50 people, as it is usually. It's not all the registrants are attending, but luckily we have Zoom and we can have our conversation translated also to Polish. Okay, so let me just briefly switch to Polish to explain our participants how to use it. Drodzy Państwo, serdecznie witam wszystkich tych, którzy już do nas dołączyli.
Dear guests, welcome.
Szybciutko wytłumaczę, że nasze spotkanie jest na język polski.
Meeting is being translated into English.
I teraz poproszę Roberta, żeby przez chwilę nie tłumaczył, bo słyszymy siebie nawzajem, więc szybciutko po polsku wytłumaczę, że wybór wersji językowej, w którą chcą Państwo nas słychać, jest na dole menu Zooma, pod taką ikonką globusa, tam jest interpretation i tam mogą Państwo wybrać język polski, czyli Polish, i wtedy będą Państwo słyszeli już tylko tłumaczenie, a nie tak jak za chwilę usłyszą Państwo język angielski, czyli oryginalną wersję naszej rozmowy. So I'm back to English. I can welcome you. My honored guests today are Andrea Woods from American Civil Liberties Union. Hello.
Hi.
And Wojciech Górowski, an attorney and also an assistant professor penal law in Jagiellońskiej University in Krakow, also a director of legal clinic in this university. Hello.
Hello, dzień dobry. Hi, everybody.
Our today's webinar is supported by US Embassy in Poland, so I would like to thank to our sponsors that helped organize this meeting. And we are having a course of webinars concerning Polish and American justice system and how they are dealing with pandemic in different fields. So we already had a conversation on domestic violence cases. We had a conversation on also online hearings, virtual hearings. And now we are meeting to talk about pretrial detention, an issue that is problematic both in Poland and the States. And I'm thrilled to have Andrea Woods here with us, who is working in project concerning criminal law reform, and also working on incarceration, prisonization reform. So Andrea, could you tell us a bit about what you're doing in American Civil Liberties Union? What's your goals, and what is the problem there that you want to solve?
Sure. Hi, everyone. Thank you for having me. As we've discussed, I think today's conversation will be a competition to see whose justice system is harsher and more punitive, the US or Poland's. But the US has a tremendous problem with overcriminalization and punishing people and jailing them too much and for too long. The United States is home to only 5% of the world's population, but 25% of the world's prisoners. And though, you know, in the last 3 or 4 decades, there's been a political movement towards being very harsh on crime. The phrase that gets used here is tough on crime. The truth is that the United States addiction to incarceration stems as far back as the 1800s and the end of American slavery and the use of jails and prisons to continue to control Black Americans. So it is a stain on our public conscience and a huge problem. On any given day, there are about 2.2 million people in the United States who are incarcerated, and about 600,000 of those are people pre-trial. So they're in local jails and they have not had their trial and they haven't been adjudicated guilty of anything. A lot of that detention occurs not explicitly. I will talk a bit later about how the US laws conceive of outright intentional pretrial detention. But what most judges do in the United States is they just impose a requirement of money bail, knowing that the person can't afford it, and that leads to their detention. A real challenge in our work, my work, is trying to end those practices and shrink the size of our prisons and address the systemic racism that's baked into that system. And I do that by filing civil rights lawsuits, lobbying for reforms. And I've also sued a number of jails for their conditions during COVID. So I'm happy to talk about that later as well. But one of the big challenges in reform is that, you know, we have our national laws in the United States Constitution that obviously provide some universal principles, but those laws are being implemented in all of the 50 US states. And it's even further decentralized because in our system, it's mostly run at the county level. So that's thousands and thousands of very small local governments that are deciding how to treat issues of money bail, pretrial detention, and pretrial release. And all too often, those are decisions that get made by a single official, a single judge who is elected, and so is worried about that political story that we have about crime and danger and needing to sort of lock everyone up. And so we've just seen in the last 3 or 4 decades ratcheting up and up and up of the numbers of people who are in jail. There's a little bit of hope. I'd say in the last 5 or 6 years, there's been more awareness of both the racist roots of our system and also how harmful pretrial detention, in particular money bail, can be. So I would say, you know, I started this work 5 years ago, and there were at any given time maybe 700,000 or 800,000 people in pretrial detention, and so that number has gone down. A few states have reformed their systems to increase release, but we've got a long way to go.
Thank you for that introduction. I will get back to some of the issues that you have touched there. But first, I would like to ask Wojciech for a similar introduction into the situation that we have in Poland now. How is the pretrial detention used in Poland now?
I think we have the same problem. Of course, we cannot win with the states with numbers. Yeah, Poland is not as big a country as the United States, but Of course, we don't have this historical background, as you said before, but we have these waves of people, and the numbers are increasing and decreasing. And these numbers are related, in my opinion, to our governments. As Bartosz and all of you knows, last numbers as Court Watch Foundation has delivered to us gave us this these numbers that since from 2016 up to 2020 we have doubled the numbers of prisoners in the pretrial detention. 4 or 5 years, and the numbers of prisoners waiting for the trials has doubled. So the issue is the same. The numbers are different, but remember, as you said before, you are facing the problem that a lot of people cannot afford the money bail. We have this big difference in our legal systems, because in Polish legal system, when the prosecutor fill a motion to the court to deliver to sentence this pretrial detention, there is no necessity of money bail. There is the big difference. So probably there is the first reason. There's the first difference between us, because in Poland, when we have this sentence and the court takes this precautionary measure called pretrial detention, the defendant has no choice. He's in prison waiting for the trial. Of course, there are some bills that the court can give this bail, but it's not necessarily part of the sentence. But it's not a mandatory, not necessarily wrong word. It's not a mandatory part of the sentence. So when we have this motion from the prosecutor, the court must decide, okay, you will stay in prison waiting for the trial, for example, for 3 months, 1 month, 2 months, up to 3 months for the first time. And then afterwards, after the 3 months, this period can be also changed by the court up to 2 years before the sentence. But there is a big reason, because, and the main issues for the main question, maybe not the issue for me, is that what has happened during the last 5 years in Poland that we increased numbers, that we increased number of pretrial detention. We have a lot of information about crimes in Poland, and the number of crimes is decreasing since we have this freedom again after 1890, after 90s. The number of crimes is decreasing. So what are the reasons? What are the reasons that last 5 years we have such a big change? Also, as Andrea said, I think maybe the last 1 or 2 years, Bartosz knows better, we are trying to discuss this issue. I cannot remember the big discussion between lawyers before. So for me, it's the first main question today. What has changed? What has happened? And remember, we don't have this historical background. Never in our history we didn't have this policy, tough on crimes, 3 strikes and you are out. We don't have this historical background. 20 years ago was the first government that they won the election with the calling tough on crimes. It was 2005, 2007, as far as I know. and was the first step in Poland. So we have the same issues and very different background, historical background, and very different rules in our legal systems. What are the reasons? Issue is the same.
So maybe I'll go back to Andrea and ask you to explain a bit more to our Polish audience what is actually the bail system, how it works, because this is unusual for Poland, as you have heard. In Poland, bail is not obligatory. Judge does not have to set a bail. It's when the pretrial detention is decided, that the court decides to send somebody to jail, simply the person is in jail until this decision is changed. So what's the difference between in Poland and US? What's the problem? Because we see bail system as a chance. Because if you have a set bail, you have this option, this possibility to leave jail. So what's the problem with this solution?
That's a great question. So not to go too far into the history, but the bail system, it was a part of the United States founding in the 1700s. It was a concept taken over from England. And the idea historically is exactly what you just said. It's that bail is a way to be released pre-trial while you're awaiting your day in court. And traditionally, it meant maybe there's a person in your community or your family who will vouch for you or look out for you and make sure that you come back to court. So it's supposed to be seen that way. And the foundational principle in our Constitution is that bail is supposed to mean release. What happened to change that story in the United States is basically a combination of, bail made sense when we were this huge country full of wilderness that someone could disappear into and never be seen again. But now it would be very difficult to flee prosecution, particularly with technology and the level of presence that our police have. So in the last, I'd say 40 or 50 years in the US, it just started to get abused as a way to detain without having to go through any of the procedures of a prosecutor bringing a motion, a court finding that detention is appropriate. In many places, it's imposed from the moment of your arrest. There's just a financial requirement that says, if you're arrested for trespassing, that's $1,200. There's sometimes it's automatic. If it's not automatic, it's still nearly automatic because so many judges have just grown accustomed to this requirement. So the way it works is it's essentially a sum of money that somebody has to generally pay upfront before they're going to be released from jail. There are a few different forms of bail. Like if someone owns property, they could put the property up as collateral and say, if I failed to appear in court, you could come after my property, but it's usually cash. The real, it's a really negative distinction that the US has here. Not only that we use this money bail system, which punishes poor people, but there's also a private industry around this. So there are companies that basically will take a deposit from someone. So say my bail was set at a $5,000 requirement, but I don't have $5,000. It's a whole industry that makes multiple billions of dollars a year that stands in and says, okay, well, we'll take $500 and we'll vouch for you. So that kind of goes back to the historical roots. Like they are vouching for you, but it's a for-profit arrangement. And then I never get my $500 back. So even though bail is meant to be an incentive that if it works the way it's meant to, I come back to court, I get my $5,000 back because it was only about me coming to court. It's been warped into both a very easy way to detain as well as a for-profit industry.
Please clear it up for us, because in Poland, pretrial detention will be used in case of crimes. or felonies that are serious enough for the person to, I don't know, there is a risk that the person will flee, or the person will obstruct justice, or the person might commit another serious crime. So it's used not in case of misdemeanors or minor felonies. Is it the case in the States? Because as you have described it, you could get an impression that basically bail is set in any case of kind of crime and kind of illegal activity, and then people can be in jail, for really not really serious issues. How is it?
That's unfortunately true. And that's where the distinction between money bail and pretrial detention as at least on paper as a concept is so important, because money bail does get imposed in the US across very low level charges all the way up. But in most states, pretrial detention authority is limited to the very most serious crimes, usually capital crimes. So that's kind of what I mean when I say it's being used as a workaround, it's being warped. So there are some places that have reformed their system so that if it's a truly low-level crime, you'll be released on the mere promise to come back to court. But it's still very prevalent, and it's exactly how people do end up in jail on low-level accusations. Sometimes they end up in pretrial detention because of money bail for longer than they could have even been sentenced on a misdemeanor charge. So it's part of why I think there's been such a awakening to the harms here. But that's right, it is generally imposed in most cases.
As Wojtek said, we lack such awakening. I think that in Poland, still the topic of pretrial detention is not as loud as in the States. And we still lack information about how harsh it is to be jailed, how severe are these precautions imposed on a jail person. Because Wojtek, am I wrong? The person that is jailed is actually under more serious and severe conditions than a person that actually serves a prison sentence, isn't it?
Of course. That's the next issue to discuss. During the pretrial detention, you cannot see your family. You can see or phone only your defense lawyer. Of course, there are some provisions that the prosecutor or the court can agree to see with your family once a month, or agree to that the defendant or the prisoner can call, for example, wife or kids. And the harshness of the pretrial detention is way more bigger than serving a sentence in prison. The door to the cells are still closed. You cannot use a phone. You cannot use an internet. You are staying in one room with other prisoners, and that's it. You are, I don't know, eating breakfasts, lunches, and waiting for the trial. Even the harsh, sometimes, I know if you see it, we have this little discussion, I know somewhere in social media, that in some civil law systems, there are some kind of, how to say it in English, some kind of different numbers. For example, what I want to say, if you are in pretrial detention for 1 year, the court can decide that it means this 1 year during the pretrial detention, that it means 2 years or 1 year and a half of imprisonment. So after the sentence is imposed and you are serving the sentence, so this first period of pretrial detention, for example, is doubled. I think we can also have this discussion in Poland because because of this issue. The harshness of pretrial detention is, I know how to say it, we are in 21st century, and the harshness is some like, I know, like medieval ages. You're waiting for the trial in four walls. You do not have a window, and you are waiting for the trial. And as all our participants know, the time is very important, because when the case is complicated, sometimes you are waiting during the pretrial detention for years. We have this very, very interesting, maybe it's not a good word, case of pretrial detention, one of the biggest frauds in Poland. And the defendant, she was in pretrial detention for 8 years. For 8 years. And she was sentenced for, as far as I know, Bartosz can correct me, 12 years of imprisonment. So it was like a penalty. Remember that we have this provision in Code of Criminal Proceedings that the pretrial detention and each precautionary measure must be applied in order to secure a proper conduct, to secure a trial. I can ask everybody. 8 years is the pretrial detention that lasts 8 years. What it secures? Nothing. It's a serving sentence before sentence is imposed. Yes. So if you ask me, the harshness is very, very, I don't know how to say, big. But remember, as you said before, Bartosz, the pretrial detention can be imposed in almost also every case in almost every crime in Poland. Of course, we have this division: crimes, felonies, and offenses, and misdemeanors. Misdemeanors, of course, if you are committing misdemeanor, you cannot be sentenced. You cannot be in jail with the pretrial detention. But remember, of course, we have these provisions that if the crime, the vice or offense, that you cannot be in jail more than 2 years, the pretrial detention cannot be imposed. But remember, we have some provisions that, for example, if you don't have a place to stay in Poland, it doesn't matter. You can wait whole year, I don't know, few months, waiting for the trial, just because you don't have the place to stay.
This is the case with homeless people that they are.
Yes, of course. And as Andrea said, we have the same problem with the poor people, because remember, the last amendment of the Code of Criminal Procedure, it was last year, I don't know, changed this bail provision. And right now, the prosecutor can verify where the money for the bail is coming from. Remember, and the prosecutor can decide, oh, I know that you lend this money from, like you've said, some firm, from your mother, from your father, and I cannot let you bail this money. Why? Okay, so then go, and then the prosecutor, if he said so, if he decides like this, can file a motion for the pretrial detention. It was last year. This amendment was, I don't know, maybe even 2021. I don't know right now.
This is another major difference in our systems, as you can imagine, Andrea. Now in Poland, this companies couldn't work in Poland. Those bond companies, because it's illegal to simply vouch for someone, which is crazy, because this is the best way to protect that the person will come to court, because someone else, someone important, some significant other vouch for the person. So now it is illegal. So it also makes it harder and harder for people to use bail in Poland.
I will add, if you ask for it, I will add one sentence. Remember that in over 95% of the cases, probably, there is no necessity for the defendant to be in court during the trial. Remember, during as far as there are some provisions that the defendant is mandated, that his staying in the court during the trial is mandatory only during the first hearing, only when he committed a felony. Remember, so over 90% of the cases, the defendant has only the right to be the part of the first hearing. So we don't have to, as we are discussing this provision about the pretrial detention, we should remember also about this. Remember, the court can start the trial without hearing even the defendant. So still, this is the next question for me: why we are still keeping people in jail waiting for the trials?
Andrea, how are the conditions in American jails? Do they differ from prisons? I have visited a city municipal jail in Louisville, in Kentucky, and actually it looked more like a hospital than a prison because of people wearing those robes, special robes like patients, and they were kind of treated like patients. What's the difference between jail and prison, and what are the conditions? This jail I have visited was very, very well equipped, but these measures of security were so severe that, for example, those people jailed there have no access to sunlight at all because there were no windows in the place where they were kept. So how long can they stay in such conditions without access to sunlight, for example?
Sure, I'm glad you asked that. And what you're describing sounds pretty common. So, you know, I don't want to repeat too many details, but people who are arrested and put in jail have all their belongings taken from them. They are put in these uniforms that look a little bit like nurse scrubs. Often have to share space in a dormitory style. So you'll sleep on a bunk bed that's bolted to another bunk bed. So you're within a few feet of 3 other people, which you can imagine during COVID was appalling because there was no social distancing. You know, there's no privacy to shower or use the bathroom. You have to spend a lot of money to get decent food because the food that is served is usually very poor and not nutritious and often rotten. So people have to spend a lot of money to get a snack that they buy in a shop called the commissary. Some jails, they call it yard time, which is sort of your exercise or recreation time. And, you know, I have lawsuits against maybe 7 or 8 jails, and there's one that's outdoors, but usually it's not. So there isn't sunlight, like you said. And unfortunately, if the jail is overcrowded and staff is short, or during COVID, there have been so many long periods of locking down a whole housing unit because they're in quarantine, because they have no social distancing or other ways to prevent the spread of COVID. So they don't get yard time, and they barely get shower or phone time. So things are especially bad now. The conditions were already bad, but they're very poor now. The difference between jail and prison, you know, a prison will have a lot of those same basics of the uniforms and the limited recreation time, and the security measures where you have to be there's many moving locked metal doors and you have to be buzzed anywhere you go. Visitation is often limited to no contact, so you're speaking through a glass panel. But the difference is that in prison, there are usually more programs to get an education or work a job. It's just, you're obviously in prison for longer. So most people that I have worked with who've been in both a jail and a prison say that at least in prison, this sort of intensity is less because people know what they're dealing with. And in jail, it's a constant churn of people being arrested, the uncertainty of how your case will resolve, worrying about your family. Jails are more violent usually for all those reasons. So prison is miserable and torturous as well, but mentally, it sounds like at least there's a slightly more of a sense of what you're doing and there's more to do, but they're both awful. Unfortunately.
I understand. It sounds awful, and does it have an impact on whether people that are jailed but feel that they are not guilty are anyway prone to play guilty, to just to get out of this place, to get some assurance?
Yes, and we have studies now that prove that. So controlling for other factors, income, charge, the single greatest predictor of a conviction in our system is pretrial detention for that exact reason, because the ordeal is too miserable. And especially for people with low to kind of medium severity of charges, pleading guilty is the way to end the ordeal and often to go home. We were talking about the length of detention. It's not uncommon for people to be in jail awaiting trial for 1 to 2 years. I definitely have heard in the 6, 7, 8 year range as well. So of course, to see your children, to get your life back on track, people plead guilty. And so our numbers are similar. We have, I think, 95 to 97% of our cases end with a guilty plea, in large part because of how awful jail is.
Just to give you perspective, in Poland, when you're pre-trial detained, the chance that you'll be acquitted is just 1%. So it's basically the same. If you're put in jail in pre-trial detention, the chances that you're gonna be found guilty are double in statistical sense. Wojtek, Andrea mentioned that during COVID, the conditions in jails were significantly dangerous for the people there. I also mentioned about sunlight because we have proofs that also getting enough sun that allows your body to produce vitamin D actually prevents from falling into severe COVID. How is the situation in Poland? Does the prison system reacted in any way on the COVID pandemic? Maybe people were released more often, maybe the time of pretrial detention went down because judges just simply decided that these people shouldn't be crowded so much in those jails. Have you observed any of these?
As far as I know, no. But remember, during the COVID pandemic, we have the special amendments, the special bills, yes, to fight against the pandemic. One of two provisions, but two, I'm not sure, but I'm sure that there was some new provisions that that gives courts the chance to shorten sentence, not a pretrial detention. That's the main reason. We have these provisions that if you are serving the sentence, for example, 5 years, that the court can argue that the health problems concerning COVID are the basis for the releasing you for prison. But it was only for this, it was only for prisoners, not for jails and not for people serving the pretrial detentions. So as far as I know, we didn't observe any changes about the length of pretrial detention. Remember, I know how the first 3 months of the pandemic, Polish courts shut down, remember that we have this provision that during this period, a lot of us didn't know what will happen in the future. Also, courts didn't know what happens in the future. But there was no provisions. There was no new provisions that that the COVID pandemic is a basis to release people from the pretrial detention. 3 months. In many cases, it means that that the length of the pretrial detentions was plus this 3 months, because there was not. Of course, there were some provisions that these cases, criminal cases, where somebody is waiting for the trial in jail, that these cases, that these cases can, that the judges can hear defendants, that they can still put these trials on tracks. But still, we have this fear in courts. We have this fear during judges, during us, during attorneys, during prosecutors. What will happen? We had no knowledge about COVID, about what will happen. And probably it was also an issue why these pretrial detentions were so the length of pretrial detentions were plus 3 months. Remember, during COVID, there were some times that even the defense lawyers, as me, that we cannot see our clients because of, as you said, as Andrea said, quarantine. It was, for example, I have some few cases that I had a phone call from my client from the jail, and she asked me, okay, we have this first hearing within 2 weeks. Can you meet me in prison, in jail? And my answer was, unfortunately, no. We can talk before the first hearing because of this COVID situation. And it was, of course, awful. Maybe not awful, it was a very big problem how to defend such people, such a person, yes? And fortunately, right now, the situation is far more better than it was a year ago or a year and a half. But still, I don't know if we have any studies what was the length during of pretrial detentions during COVID pandemic, during start. Remember, of course, if we have this very, I don't know, severe crime, it's felony, murder, second, first degree, of course, we don't have this division in Poland. Maybe it's not a problem. You will wait, not as big problem as in vice or offenses. You will wait for the trial for 3 more months. But for example, as you mentioned, trespassing, yes, 3 months is a lot. 3 months is a lot. So, so I think answering your question, we have only new provisions, but it was for the people that were serving sentences, but not for the people during pretrial detention. Mm-hmm. Of course, I must say, I am acting also as a defense lawyer. I have some cases that the prosecutors decided that the pretrial detention has ended and my client was released because of COVID. But it was the decision of each prosecutor in each trial, because in our system, during the prosecutor can decide about releasing from jail. Of course, the judge, the court is imposing the pretrial detention, but prosecutor in any time can decide about releasing. So I have a few cases that because of COVID, although there was no provisions, my clients were released from prison, and it was no, there was no base, there was no some basis for this decision in our law. I think these decisions were made because of some humanity reasons, because of health status of my clients, and also because of the fact that our jails were and still are overcrowded. As you said before, we have the same conditions in our prisons.
Andrea, before I give the floor to our attendees and let them ask you some questions, because I'm sure that they have many, we have already some discussion here in chat. I would like to ask you for about something that you know that you're doing. I know that bad litigation. You're trying to urge lawmakers to provide changes and in the system and to replace pretrial detention with, as you call it, smart solutions. So not to be tough on crime, but to be smart on crime. So could you explain us what are those solutions? What are those solutions? What can be done to change the numbers? What can be done to make those conditions less miserable? And maybe there are different institutions, maybe there are different technical solutions to protect the course of trial, the course of procedures, and not keeping people in custody.
And also my question, how much money do you need to do it? Because in Poland, as far as you all know, sometimes it's all about the money.
Mm-hmm. Same. Yeah. So, yeah, and I will just note that I think some of the questions in the Q&A touch on this, and the tension that we experience is that we have these principles of due process, of presumed innocent, of equal rights. The trick is that in practice, in execution, the world looks so different. So we drew some great questions about, well, what was the point of bail if all these people are being detained? And it's like, exactly, that's what we're trying to say. So our advocacy and vision is one in which pretrial detention is a matter of last resort. It's all but eliminated. I think, the ACLU has settled on a policy platform that every jurisdiction should release at least 95% of people, because the truth is, we know from data and from, again, our legal principles that the vast majority of people do not present a flight risk and they do not present a risk of harming anyone. They just need to be given a chance. So we think that the US and its states need to divest, so stop spending so much money jailing people. Jailing people is really expensive. It usually costs a couple $100s per person per day. So in a big city, that's tens of millions of dollars a year. And reinvest in solutions that both will work better and keep communities safer, because pretrial detention leads to worse outcomes and more future criminal justice involvement, but also will be more humane. So there are some models that we like giving people the opportunity to receive a reminder on their phone via text message of their court date, instead of being tracked by a GPS or by a company who could be very abusive to them. We've seen a lot of success with something as simple as that, and that costs $2 per person per year instead of hundreds of dollars per day. Also very interested in models that sort of take the individual and assess their needs. So a lot of people are going to need help getting a ride to court, or maybe help with housing or treatment for mental health or substance abuse. So we want to sort of turn this on its head, and instead of building systems that just take people out of society, make them worse off because they lose their job and their stability, get them into society with the right supports. And the encouraging thing is that we do have some models. We have community-based or charitable bail funds that are proving that this works. These are organizations that pay someone's bail to get them out of jail, gives them some of those basic supports and check-ins, and their clients tend to appear in court in, high 90 percentile. They don't get in trouble, and half of the time their cases are dismissed because we know that police overcharge behavior. So it's kind of a long vision, and we're trying to chip away in steps to get there. First, by vindicating what the law is supposed to say and get more people out. In terms of how much money it will take, I wish I knew more of the specifics, but we do know that supervising people instead of detaining them costs about 1/10 as much. So it's much cheaper. And so we'd like to see kind of more of that rigorous process. Like, again, in the US, people are being detained sometimes without a prosecutor's motion or without a judge deciding. And we hope that that process, paired with some of the political advocacy that we're seeing and the availability of other solutions, will get us much closer to that.
Can I ask a question to Andrea?
I think so.
What do you think about electronic supervision? Because we don't have it in Poland as an issue in the pretrial detention. You can serve your penalty, you can serve your sentence with this electronic supervision, staying home, going to work. But what do you think? We are starting this discussion right now that maybe the electronic supervision, home arrest, home detention is some kind of solution.
So we think that it's something that you should have on the menu because it's less punitive than jail or prison, but it's still a very significant intrusion and of privacy. And a lot of people, the way that works in function is they wear this ankle monitor that's big and clunky.
Like in Poland, yes.
Everyone knows what that is when they see it. It's hard to get a job when you're wearing one of those. So we think keep it on the menu because it gets people out of jail, but it should only be imposed if there's a very serious case or a very serious flight risk or something like that.
Okay, thank you.
I encourage our attendees to take a chance to ask questions by using chat. And before we have some new questions, I would like to ask you, Andrea, about pretrial risk assessment. Is it done how it's done, and do you see also use of knowledge data that you gathered? As you said, that most of the people that are put in jail, they would appear in court anyway. If there would be oversight, for example, helps in any way, like with this message, remember to recall them, to tell them when the date is to go to court. But what about those risk assessment in setting bail? Also, how you find using this AI, artificial intelligence, in assessing this risk in different cases? Because I know that in the States it's already implemented for risk assessment in pretrial.
Yeah. So there's been a big movement to introduce algorithmic risk assessment tools. So just what you said, these are predictive tools that use real world data, and they identify factors generally related to someone's criminal history that are associated with a higher risk of missing a court date or being arrested. The trouble with those is that they're built on real world data, which is built off of bias. And so the exact same people who are being over policed, which in the US are poor people and minorities, are the most likely to have the kind of criminal record that tool is going to identify as risky. So we've gotten some good information from those tools. Like, that's how I know so many people are actually very low risk, because we have that data. The problem is that in practice, again, when we turn over a tool to a judge who's usually not a statistician and doesn't understand the math or the forecasting, all the judge sees is high risk. Okay, they're going to jail, and so high risk means maybe an 8% chance of arrest in a 6-month period. So high risk is actually very low risk. And so that's what I usually try to stress, is handing these tools over to decision makers has probably done not that much good, unfortunately, because the same bias and the same instinct to detain is always there. So we think that instead of a county or a state investing a lot of resources in introducing that tool and getting their computer systems able to use it, those resources are better spent on court reminders, rights to court, childcare, and housing. But as an advocate, there are still useful things that we've gained from them. We don't support their use to inform a detention decision because they get misused in practice.
That is very interesting insight, while basically having experience with that. Do you think that something will change in the near future as you try to change the system? You already said that you have a decrease of people put in jail in recent years. What are your hopes for the close future?
That's a nice note to end on. So my hope is that more and more places experiment and show that you can do things a different way. I think that's the most powerful evidence for lawmakers is, look, we have this entire city that doesn't use detention in this way, and their outcomes are pretty good, right? The sort of expression that I say is the sky didn't fall when you tried a new way. It actually worked really well, but a lot of politicians aren't that imaginative. So I find a lot of hope when we get models like that we can tell others about, and those kinds of local efforts are happening. The other thing that may happen in the next few years is that the United States Supreme Court will weigh in on some of these principles of due process and equal protection, which they've never have before. There's never been a case that actually asked them, when you jail someone on money bail they can't afford, is that unconstitutional? We've gotten a lot of lower courts to say that, but if the US Supreme Court were to say that, it would be very helpful.
Wojtek, what are your hopes for the future? What would you like to change in Polish system, in attitude of judges that are deciding on pretrial detention?
I don't want to say that I have no hope, because it will sound awful, but sometimes when I am thinking about your question, I have no hope, because as Andrea said before, we have the same issues. We have also these provisions about due process, about equal rights of each party during the prosecutor and during the trials in the court. And the practice is very different manner. My hope is that courts, judges, prosecutors, all of us will hear that the jail, that the pretrial detention means that someone will be in jail for, I don't know, without family, without any, I don't know how to say it, goods, for a long period, as far as he still is innocent. We are the jail, I know, maybe the main hope for me, the main thought for me is the pretrial detention is the same as an imprisonment penalty. But the main reason is the imprisonment is after you are convicted. And that's it. For me, it's the biggest reason. And waiting for the process, the harshness of the pretrial detention, the harshness of pretrial detention means that somebody is waiting for the decision of the court. One last sentence probably about this risk assessment. Remember that in our Code of Criminal Proceedings, we have these provisions that each pretrial detention means that is a very high risk that are many factors that the judge must see and say, oh, there is very high risk of the assessment during the trial, that something wrong will happen during this trial, during the trial. We don't have any algorithms. Remember, in Poland, we have only the judge decision. That's it. We have no algorithms. I remember
it's intuition, basically. Intuition, judges.
Yes,
intuition.
yes, for me, yes. It sounds terrible, but I remember 3 years ago, as I was in Maurer Law School at the Indiana University, we had this conversation with Professor Hoffman about algorithms, about the penalties, about the imprisonments. It was like the same that you said about the detention. Problem with poor people, with minorities. And this algorithm works. Oh my gosh, he was in prison for the last 2 years. Oh, we should put him in prison for the next 10 years. I don't know what is worse. What is worst, this algorithm, or I don't know, as you mentioned, intuition of the judge. Both are terrible.
The big secret here, though, is that the algorithm never replaced the judge. So all you did is give the judge one more piece of information that they tend to use wrongly. So I think that it's a false policy choice in the US. People say, well, should we use the algorithm? But the truth is the judge's intuition is always going to be the thing that wins the day. So that's why we don't support them. We think it's not a good use of resources.
So maybe the recommendation that we should make is to educate judges how they should interpret those risk assessment results.
Yes,
Andrea, Wojciech, I want to thank you because we are already at 6 p.m. in Poland. So we promised our attendees that, and also to you, that our meeting will take 1 hour. It was very interesting hour. And it was very interesting discussion. So big thanks, Andrea, for finding time, for sharing with us your knowledge and experience. We keep our finger crossed for you, for your efforts. I hope that your dreams, your hopes will come true. And I'll also hope that Wojciech will have more positive and optimistic attitude in the future as we also make some steps to improve our system. So thank you very much. Once again, thank you to our sponsors from US Embassy. And also I would like to give credit to Michał Popiela, who is serving the technical issues here, to Robert Piórkowski, who is the interpreter, and Samuel Shannon, who helped to arrange this meeting. Thank you, and see you on the next webinar with Court Watch Poland Foundation. See you again. Thank you.
Thank you.
Thank you. It was a big pleasure for me. Thank you very much.